Hello, my name is Natalia Porsche and I am an immigration attorney in the United States. And this video will be about recent decisions, specifically decision of Supreme Court to end the MPP program and decision of the federal judge in Texas, Judge Tipton, to and Doyle Memorandum. Well, first of all, let's discuss the decision of Supreme Court, which was rendered on June the 30th, 2022, ending MPP program, right? What is MPP program? Well, MPP program was established by former President Trump's administration, and that provided that people who were seeking asylum in the United States had to remain in Mexico. Okay, so this law, as well as the law Title 42, they both prevented, I can say prevented because this law is not active anymore. However, Title 42 remains active, right? So although we can argue that this law is not active anymore, people still cannot come in because Title 42 is still active. Well, let's see what's going to happen with Title 42. Let's watch this closely and see what's going to happen. However, this program ended now as of June the 30th, 2022. So what happened in this case? Well, in this case, we know the state of Texas was fighting with Biden's administration, right? The case was, first of all, it came from federal court in Texas. Then the case went to on appeal to a Fifth Circuit, and then Fifth Circuit rendered decision in favor of state Texas, and of course it was appealed to the Supreme Court of the United States, and Supreme Court of the United States says no. Biden administration is correct, and it has full right to end this MPP program, which is Remain in Mexico, also known as Remain in Mexico. So this was a huge win. It was a huge win for the Biden's administration. First win, and let's see what's going to happen with Title 42 program, which prevents, as I said before, prevents people to come into the United States and seek asylum over here. Also, the Biden administration argued in this case that a lot of people died because the asylum seekers had to remain in Mexico and apply for asylum and wait for their asylum case in Mexico. So that created a lot of dangerous conditions for them, as well as created a lot of unnecessary deaths and unreasonable food shortages in Mexico and stuff like that. So that was the main argument that the Biden administration presented to the Supreme Court of the United States, and it won. Okay, so that was about the Remain in Mexico program and recent decision which was rendered by the United States Supreme Court. What does it do? Well, really at this point, it's a huge win. No one can argue that, but with Title 42 being in place, we still struggle. We struggle because people still cannot come into the United States and seek asylum over here, except some major exceptions, right? As a minor children, for example. Okay, so let's talk about a second very major opinion that I believe now is on appeal again on appeal in Fifth Circuit. We have Judge Tipton's ruling regarding Doyle's memorandum, right? So what is about Doyle's memorandum and what happened exactly? So we all know about Doyle's memorandum, right? Doyle's memorandum is the law that was enacted by Secretary Doyle, DHS Secretary Doyle. It was enacted, he's actually, Principal Legal Advisor Kerry Doyle. He enacted this memo on April the 3rd, 2022. And what it provided, I can say provided or provides because I believe it's on appeal again. So I would say provide to remain a positive hope for the outcome. So what it provides is that it provides three main let's say, discretionally measured, right, which DHS will had to apply in order to see whether the person is eligible for prosecutorial discretion for a favorable exercise of prosecutorial discretion. So what is a prosecutorial discretion? Because it's still enacted, right? People still can apply for prosecutorial discretion. However, this, in my opinion, and I think this specific memo, unlike the September's Alexander Mayorkas memo, this memo specifically gives a little bit, provides DHS attorneys, OPLAS attorneys, guidance, very specific guidance to determine who are the first priority, right? What are the first priority cases, right? So the first priority cases, what this memo provides is that it specifically distinguished and separated cases which are the first priority cases, such as people who are threats to national security of the United States, people who are threats to public safety of the United States, and people who are threats to border security of the United States. So unless you qualify, unless you fit in those three categories, DHS attorney had to give you this discretion, right? And perhaps administratively close your case. However, at this point, this memo does not apply anymore. So essentially, this memo provided people who had very minor criminal offenses, such as misdemeanor offenses, for example, no driver's license, no insurance, and etc. For example, if you live in a state and you're undocumented immigrant, you're a foreign national, you live in a state which does not provide driver's license to undocumented people, right? So you, therefore, you accumulated few traffic tickets. So this Doyle memo, which we had before, because it's overturned now by Judge Timpton, federal judge in Texas. So that memo essentially kind of give you a way out, right? If you're in deportation proceeding, if you have few misdemeanors, then under Doyle memorandum, OPLA attorneys will have to close your case, because arguably you are not a threat to national security, because your offenses are not major offenses. You paid all your fines, they're minor offenses. You are not a threat to public safety, because arguably that no driver's license does not subject to anyone to a kind of a safety violations. Yes, it is an offense, but arguably it's not a major or violent offense, unlike some felony offenses, right? Some violent felony offenses. And you're not a threat to border security, because arguably you came into the United States and the United States government know you're here since you presented yourself at the border, let's say at Mexico, right? At Mexican border. Therefore, you could, under the Doyle memorandum, fit in this, right? In this, that you don't qualify, you're not threat to national security, that you qualify the Doyle memorandum for your case to be dismissed. So now it's not the case. Although I believe the government did appeal, DHS did appeal this to Fifth Circuit, and let's see what's gonna happen, whether it will go all the way up to the Supreme Court of the United States. But at this point, so what you still can do, let's say, what can you do if you don't have any criminal record, right? Can you still qualify under Alexander Mayorkas' September 2021 memorandum for favorable exercise of prosecutorial discretion? Well, arguably, of course, you could, right? Because you are not, although this does not apply to you and we cannot exercise these principles anymore under Doyle's memorandum, arguably you still fit, for favorable exercise of prosecutorial discretion under September memo. And OPLA attorney can definitely see if they still have a discretion. So what this Judge Timpton's ruling say? Well, Judge Timpton's ruling says that his only concern is about aliens or foreign national with a criminal record. So that's the main concern. He talked a lot, in his opinion, about this criminal ground and in a Doyle memorandum, right? He was saying that aliens with criminal grounds should not be subject to a favorable exercise of prosecutorial discretion. That's what his opinion said, right? So now this opinion was issued back in June, Now it took a final place on the 27th of June 2022. So from 27th of June 2022, I believe it was appealed to Fifth Circuit, but it's not actionable anymore. So if you have an attorney and you decided to apply for prosecutorial discretion, you're more than welcome to do so, because you still can go through fingerprints process. You can show the OPLA attorney that or DHS attorney that you don't have any criminal record, therefore they still can exercise discretion. So essentially, this Judge Timpton's opinion, it doesn't prevent OPLA attorney from exercising discretion, right, to close your case. It still gives them discretion, so it didn't completely vacate those memorandum, but it just says that each case is different, right? So each case will have to be looked at differently from different perspectives. So that's what it was. That was the opinion of Judge Timpton's federal Texas judge from Northern District of Texas, which is now pending on appeal, I believe, on Fifth Circuit, and maybe we'll see a Supreme Court decision on that too. So if you like this news, if you like how I delivered this news to you, subscribe to my channel, put like. Thank you for watching and have a great day. Bye-bye.